What is NYPL Section 220.03 Criminal Possession of a Controlled Substance in the 7th Degree? New York Penal Law Section 220.03 makes it a crime to knowingly possess any amount of a controlled substance. This is the lowest level drug possession charge in New York, but it is still a criminal offense. A conviction can lead to jail time, fines, and a permanent criminal record. Criminal possession of a controlled substance in the 7th degree is classified as a Class A misdemeanor. You commit this offense when you knowingly and unlawfully possess a controlled substance in any amount. The law does not require prosecutors to prove you had a large quantity of drugs. Even a small amount of cocaine or prescription medication can trigger an arrest. Knowing possession means you were aware the substance was in your pocket, bag, car, or home. You do not need to know the exact chemical name of the drug to be charged. Unlawful possession means you had no legal authorization, such as a valid prescription. The amount of the substance determines whether the charge stays a misdemeanor or becomes a felony. If the weight is below felony thresholds, prosecutors often charge NYPL Section 220.03. Possessing larger quantities can result in higher-degree felony drug possession charges. The maximum penalty for 7th-degree drug possession includes up to 364 days in jail. A judge can also impose a fine of up to $1,000. Probation of up to 2 or 3 years may be ordered instead of incarceration. Even as a misdemeanor, this charge can affect employment, housing, immigration status, and licensing. Some first-time offenders may qualify for alternatives such as drug court programs. Successful completion of treatment-focused programs may result in dismissal of the case. An adjournment in contemplation of dismissal may also be available in certain situations. NYPL Section 220.03 applies to many substances listed in New York Public Health Law Section 3306. This includes narcotics, stimulants, hallucinogens, and certain prescription medications. Cocaine, heroin, fentanyl, and methamphetamine are common substances prosecuted under this law. Prescription drugs like oxycodone, Percocet, Xanax, or Valium can also lead to charges if possessed without a prescription. Even possessing someone else's pills can result in criminal liability. New York law provides important exceptions to 7th-degree possession charges. One exception applies when the only drug present is a residual trace amount in a legally obtained syringe. This reflects public health policies tied to syringe exchange and expanded access programs. Another exception comes from New York's Good Samaritan overdose law under Penal Law Section 220.78. If you seek immediate medical help during an overdose emergency, drugs discovered as a result may not be prosecuted under NYPL Section 220.03. This encourages people to call for emergency assistance without fear of arrest. A skilled drug possession lawyer can often challenge these cases based on how the evidence was obtained. One common defense involves unlawful search and seizure under the Fourth Amendment. If police searched your car, home, or person without a warrant or legal exception, evidence may be suppressed. Suppressed evidence cannot be used by prosecutors in court. Another defense is lack of knowledge. The prosecution must prove you knowingly possessed the controlled substance. If drugs were found in a shared apartment or someone else's vehicle, it may be difficult to prove awareness. Constructive possession is also frequently disputed in these cases. Actual possession means the drugs were physically on you. Constructive possession means prosecutors claim you had dominion and control over the substance. When multiple people have access to the location, constructive possession becomes harder to establish. A complete defense exists if the substance was legally prescribed to you. Documentation such as prescription bottles or medical records can defeat the charge. Arraignment is usually the first court appearance after an arrest or a desk appearance ticket. If you are held in custody, arraignment must occur within 24 hours at Bronx Criminal Court. During arraignment, the judge informs you of the charges and conditions of release. Having an attorney present allows you to begin building a defense immediately. David Mejia Colgan, Esq., is a Bronx criminal defense attorney and former assistant district attorney with more than 30 years of experience. He has handled drug possession cases throughout New York City and understands how prosecutors build these charges. His law firm works directly with clients to challenge weak evidence, fight illegal searches, and protect their rights. If you are facing a NYPL Section 220.03 charge, you should speak with a qualified lawyer as soon as possible. An experienced attorney like David Mejia Colgan, Esq., can evaluate defenses, negotiate for dismissal, or reduce the impact of your case. David Mejia Colgan, Esq., is located at 910 Grand Concourse Suite 1F, Bronx, New York, 10451 and can be reached at 718-484-8820.